We're here in New York City, downtown Lower Manhattan, in the Second Circuit, and where we just had oral arguments, very, I don't know, I'd say you did combat, but legal combat with some federal judges, and there were two present, and there was one via the
stream,
watching online because
yeah.
he wasn't feeling well.
Yeah.
In a very beautiful building. You can see the courthouses back here, kind of nice, but Barry, this was on the Connecticut assault weapons and magazine ban.
Exactly.
And so why don't you give a little taste of what we saw today.
Okay, so it was combat is a good word for it. One judge in particular was extremely feisty, obviously for the state, and didn't hide that very much, and didn't really like our argument, even though our argument is very simple based on Heller. The state admits that these weapons are owned by millions and millions of people. Millions of people. The state also admits that they're rarely used in crime. You combine those two things, that's a protected weapon under the Second Amendment. Both Bruen and Heller, very, very clear. And the court is going to have to do a lot of jurisprudential gymnastics to hold otherwise, because this is a simple case.
Well, and you said the state already admitted that and stipulated to the concept that 99.98% of semi-automatic so-called assault weapons were not used in crimes.
Well, that's exactly right. So the state put on evidence, and its evidence was there were 24 million of these so-called assault weapons out there. And also the evidence was the number of people killed by these so-called assault weapons was less than 100 in a particular year. That's 99.998 of the weapons they want to ban because of the 0.002% that were used in crimes. That under Heller, under Bruen, that is absurd. It's a simple case, and the state wants to say, well, these are just really dangerous weapons. The whole point of Bruen, the absolute whole point of Bruen, you have to be pretty obstinate not to read Bruen and understand that its whole point is judges don't get to make that determination about which is the most appropriate weapon for the citizens to use.
If I had to sum up what the judges' questions were, they were basically, how can I get around Bruen and Heller?
So basically the judge that was hostile to Bruen and Heller was talking about ways to wordsmith it. So, for example, she said under Heller, you can't ban a weapon unless it's dangerous and unusual. Well, she says, well, that really kind of means unusually dangerous, doesn't it, Counsel? Well, no, those are not synonymous
They're different.
phrases.
They're different
absolutely.
because
Yeah.
they were debated. They've been debated in court a number of places.
Yeah.
So, because if you said dangerous or unusual, it could be one or the other.
Yes, right.
And you were making the case, well, I mean, of course, all firearms are dangerous, largely. The question is, are they unusual? And Bruen very clearly holds if they're in common use, you can't ban them.
That's right. So the whole point of Bruen, again, is judges need to get out of the job of making these, quote, difficult empirical judgments about whether firearms are appropriate. This is not Barry Arrington, this is not Dudley Brown, this is the United States Supreme Court. Difficult empirical judgments about the relative merits of a particular firearm are just utterly irrelevant. Because if all a judge has to do is append the word unusually onto the word dangerous, no firearm is protected, because you can figure out a way to call any firearm you want to unusually dangerous.
We filed this a couple years ago, and this is the oral arguments in front of the appellate court judges. Am I saying that right?
That's correct.
So I'm not the attorney.
Yeah.
That's why we have you. You're the expert.
Yeah.
And you as you argue this in front of them, you're essentially saying you've got to overturn what this district court judge said.
So the district court, we applied for an injunction against this blatantly unconstitutional statute, and the district court didn't give us that. And so we're up here on the appeal asking the Second Circuit to send it back down to the district court and say, yeah, you got it wrong. You should have entered an injunction.
Now, this gives us a little bit of a taste of what we know Connecticut will do with the U.S. Attorney's Office and how they will argue this should we get to trial.
Right. They'll make the exact same arguments. These weapons are just too dangerous to let citizens have, even though they admit that the overwhelming, literally 99.998% of them are used for lawful purposes. Still too dangerous to let citizens have.
Now, you said they kind of started asking a question about really how common are they, and you said they're the most common firearm sold in America. Most common rifle is the AR-15.
Right.
And that's really what we're talking about, is an AR-15 and its style of firearms. So it was and they ran away from that really quickly.
Right.
And I noticed the state didn't try that.
Well, the state tried to end to run our evidence at trial, saying we just couldn't tell which of these list of firearms they were trying to ban. Well, nonsense. The evidence was overwhelming. As a matter of fact, almost exclusively about AR-15s at the trial court level. And so the state said, well, we just couldn't tell which of the arms that they want to ban, and that's the plaintiff's fault for not telling us.
Now so now the one of the judges started asking about functionality and the difference between an M16 and an AR-15. Mm-hmm. And it became clear that one of them clearly didn't know the difference.
Right.
And couldn't actually be.
Well, let me interrupt you right here. That is the whole reason Bruin said you got to get judges out of the business of making distinctions between firearms, because judges don't know beans about firearms. And so do our constitutional rights really depend upon whether we can convince a judge to like a particular firearm?
Yeah.
If that's the case,
we're done.
We're done.
We're done.
Right. Yeah.
We might as well just go home, and we're back to square one.
Yeah.
Which, of course, when they don't know, they really don't know about these firearms, and even when you show them and explain that to them, as Thomas Massey said in some congressional hearings in the Judiciary Committee, he explains it, and he shows them why they don't know what they're talking about, and they get a little red-faced, but they keep charging forward. They said, oh, it doesn't really matter. No, actually, it doesn't really matter the other direction. You don't need to know the difference because you're going to try to ban them anyway.
Yeah, exactly.
Now, the bizarre part about all of it is that the little games that are being played are largely, it sure seems like the state and the judges are trying to get away from actually being bound by the Bruin and Heller decisions.
The entire point of all the Court of Appeals decisions after McDonald in 2010, how do we get around McDonald? And in Bruin, the Supreme Court said, you know what? You got it wrong. We've sat here and watched you for 12 years. Every single one of you got it wrong. And so we expected in 2022, okay, we've got a new sheriff in town, so to speak, and they're actually going to start enforcing the law. But unfortunately, we kind of got business as usual. There have been 18 arms ban cases decided after Bruin. The government is not 17-1, not 16-2, not 15-3. They're 18-0. It's business as usual. Right. It's really kind of frustrating, and so it's going to take probably another Supreme Court case where it's going to say, you know, the most popular rifle in America, where we said you couldn't ban weapons in common use for lawful purposes. Well, yes, the most popular rifle in America is one of those.
Right. Well, now it's odd to be arguing and wearing this lapel pin in New York City. This is not the world's most friendly, Second Amendment friendly city.
That's an understatement.
And just a few weeks ago, you were with Hannah Hill and arguing in the First Circuit in Boston, again with the Massachusetts assault weapons ban. Not a really Second Amendment friendly area, city, or circuit.
Well, that's what I'll say the same thing I said to Hannah. But almost by definition, the courts that you're going to be arguing these cases in front of are not going to be Second Amendment friendly. Otherwise, you wouldn't have to argue them at the appellate level because you'd already gotten the decisions that you need. But what we are doing now is the equivalent of what the Second Amendment community did after McDonald. Pounding on the door, pounding on the door, pounding on the door. And with the hope, the expectation that sooner or later, the Supreme Court's going to open the door again and clarify the matter, and these are weapons you can't ban.
And this is an outrageous attempt by NAGR. I mean, this is really gutsy for us to come and operate in these areas. But we looked and said, if we can beat them at one of these places, we can beat them everywhere.
Well, that's the thing about the gun bans. You have to go where the gun bans are, which are blue states, right?
Yeah. So we're excited, and we hope, our hope is that we're alive when soon the U.S. Supreme Court dives in and says, and makes another big decision, hopefully written by Clarence Thomas again.
It could be as this term, the Snope decision out of the Fourth Circuit, which this court actually cited, is up on a petition for cert, and we could hear as early as 2025, the spring, from the Supreme Court on this issue.
We'll see.
Okay.
We'll get more on the next fight, so stand by.